My name is Tim Faith. I'm the chair of the Baltimore County Bar Association's Technology Committee. Thank you for joining us today. We have Judge Clyburn here to talk a little bit about the e-filing initiative in Maryland for all you litigators out there. Hopefully you'll learn a few things this afternoon. So I'm going to introduce Judge Clyburn to you, and I'm going to turn the podium over to him to talk to you a little bit more about the details of this. So, Judge Clyburn is the Chief Judge of the District Court of Maryland, which is a statewide 34-location court system. He leads a staff of more than 1,800 people, including 100 judges who preside over civil and criminal and traffic cases. And I believe, Judge Clyburn, you said there's almost 2 million cases a year that go through the district court system. So it's a busy court system in Maryland. There are no juries, of course, so you are in front of a judge as a litigant, and every single one of those cases involves a judge with you. Judge Clyburn has served as the District Court's Chief Judge since December 29th of 2004, when he was appointed by the Maryland Court of Appeals Judge Robert M. Bell. Judge Clyburn was born in D.C., grew up in Baltimore, graduated from Baltimore Polytechnic Institute before attending the U.S. Air Force Academy and the U.S. Air Force Academy Preparatory School. After an injury ended his plans for a career in the Air Force, Judge Clyburn returned to Baltimore and completed his undergraduate studies at the University of Maryland in 1978 and went on to study law to receive a Juris Doctorate degree at the University of Maryland in 1981. Judge Clyburn is here today to talk more about the e-filing initiative in Maryland. Has a big impact on everybody that practices law that has to deal with the court system. And I hope that you will enjoy this presentation. And again, thank you for coming. Judge Clyburn.
Good afternoon, everyone.
Good afternoon, Judge.
President Gillis, are you still here? Okay, I see it's a casual day for you. That's good.
This is the technology fair.
The technology fair. Let me first of all do a little housekeeping. Actually, today I'm appearing in my capacity as chair of the Maryland Electronic Court Initiative, and we're actually going to change this title our next presentation. But thank you for having us. I'd like to start by doing a little housekeeping. Each of you should have a packet. In the packet, on the right side, you're going to have a PowerPoint. This is a copy of the PowerPoint that we're going to go through very quickly today. On your left side, you have a brochure. There's a letter that we wrote to the Bar Association back in 2010, which they have not responded to. The e-filing, there are several articles there that deals with e-filing. How many people in this room remember carbon paper? You remember? Okay. How many actually use carbon paper in your practice?
Currently?
Carbon paper.
Currently?
Somewhere during your practice. Okay, you just aged yourself, I guess. You know, when you look at what's going on in society, I'm sure now most of you have iPads, 1, 2, 3. You have, you're Twittering, you're tweeting, you're doing Facebook, you're shopping, you're paying your bank accounts, you're paying your bills, you're banking. Some of you are actually dating online. That's an example of what's going on in society in terms of where we are in the area of information technology. There's now a demand for immediacy when it comes to information that's used on which you make decisions in your life. And when you look at the criminal justice system, when you look at the justice system, the courts are really the hub of the universe when it comes to information. Much of what you do is driven by what we do in terms of our decisions that we make. You know, the denials of your requests for postponements, that was supposed to be funny. In any case, the commitments, everything we do, that information basically drives your practice. The problem is, this is the environment that we currently use. It's called this stuff called paper. It's an environment, and this actually looks like Mike Vock's office. Mike Vock was here a few minutes ago. This actually looks like Catonsville the courthouse that we're trying to replace now. We are just busting at the seams when it comes to storage of paper. This paper also is very expensive. It's expensive to manage this stuff. We have to receive it, index it, file it, try to locate it, copy it, and mail it. This is also very amenable to being destroyed. Look at Prince George's County. We have 2 fires there in Prince George's County in the circuit court. So we are actually, when you look at the rest of society and you look at where we are with the judicial system, we are really about 5 to 8 years behind where we should be in terms of society. And I think that's a sad statement because the judiciary, we are making decisions every day that has an impact on the lives of our citizens. There's really no good reason that we should be so far behind in terms of technology. Now, who are the big civil litigators in this room? Any civil litigators? None? Okay, civil litigators. There's a state, one of the Midwestern states actually did a study when they decided to do their e-filing project. And what they found is this is what civil litigators are doing to this world. For your typical large civil case that starts at your trial court and goes all the way up to your appellate court, it actually takes, and they actually counted the reams of paper, it actually takes about 3 of these, 3 trees to process that. Any of you have been down to the appellate courts, the Court of Special Appeals, the Court of Appeals, you sit and you watch boxes and boxes and boxes of this stuff, of paper. So today, what we would like to do is give you an overview of a new project. Actually, it's not a new project. This is, I guess, my 65th talk on this. But we've been working on this for about 4 years. But we want to give you an overview of where we are and where we're going with the electronic court. We also want to share with you the proposed vision. And I have with me today Joan Nairn, who is the project director, and also Rob Prender, who is the deputy chief court commissioner for the state. Joan's going to give you an update of where we are relative to the issues that the Rules Committee is currently looking at. This is probably the most far-reaching project that the judiciary has ever undertaken, other than the creation of the district court back in 1971. This project is going to have a major impact on how you do business because it's going to impact your profit model, the model that you currently use in terms of how you file with the court. So this is going to be major. And what this is actually going to be is it's a new tool. It's a new communication tool. It's more than just a case management system. It's actually a system that's going to include e-filing, document management, content management, case management, interoperability, integration with both law firms and justice partners. And this communication tool is going to do 3 main things. First of all, if my appellate friends don't back out, this is going to electronically integrate all levels of court. Imagine this. We currently have 8 case management systems throughout the state, and those case management systems do not communicate. They do not talk. This project, we're going to replace all 8 case management systems, and with this project, the district court, circuit court, Court of Special Appeals, and Court of Appeals will all be under one system, which means that the record as you know it is going to electronically move from the district court all the way to the Court of Appeals. This is also going to give us an opportunity for the first time to produce and communicate real-time data. If I can get my good friends on the circuit court to come along with us, Circuit court judges now will actually be able to touch a screen, they'll issue a bench warrant, and that bench warrant will electronically transfer over to the Department of Public Safety. We know this because last February, we successfully moved this information electronically to public safety. I guess I shouldn't be so tough on the circuit court. Circuit court, though, if you look at the circuit courts, and this is the real purpose of this, the circuit court's a lot different than the district court in that the district court is a uniform statewide court so that everything you do, either in Western Maryland, Lower Shore, Southern Maryland, you all do it the same way. Whereas the circuit court, you may do the one procedure business practice 24 different ways. Under this new system, we are moving towards efficiency, and we're going to do everything the same way. So you can imagine that there was a little pushback on the circuit court. This is also going to create a paper-on-demand environment, which means that if you need paper, you can always get paper, but paper eventually will become the exception as opposed to the standard practice. How did we manage to get this through the legislature at a time when we're dealing with, the fiscal situation that we're dealing with? The business case that we made at the legislature for the past 2 or 3 years has been one of public safety. This is going to increase the fair and efficient administration of justice, and it's going to increase access. I can say that the legislature is with us. So far, the legislature has appropriated about $28 million this year. They should appropriate another $8.6 million. So we have spent about $28 million on this project so far. So we are well on our way in terms of getting this done. Also, there's a sense of urgency. We are currently operating in a system called legacy. Well, legacy is about 30 years old and it's obsolete. So as a result of that, we are finding that our pool of experts is rapidly diminishing. So we really don't have a choice. We have to move from this legacy system. Public safety. What keeps me going in terms of when I have judges yell at me, and I've had a couple of judges yell at me. I've had an appellate judge accuse me of living in cyberspace. I had a friendly circuit court judge at a dinner one night scream at me about making him a high-paid data clerk. So when I get that type of pushback, what I do is I think about a lady by the name of Miss Lancaster. You may recall years ago down in Southern Maryland, there's a lady who one Friday afternoon decided to go shopping for a funeral. She took a girlfriend out, and she actually picked out the dress. She wanted a pair of shoes because she had been barefooted most of her life, so she wanted shoes in her coffin. She took a handkerchief, she laid exactly what she wanted to include in her coffin. Why? Because she knew that her husband was going to kill her. She managed to make it to the court. A judge signed the bench warrant, but the bench warrant sat on someone's desk. The warrant was never entered into the system. And that next day on Saturday, he came over and killed her with a 12-gauge shotgun, went out on the front porch and sat down and killed himself with the 12-gauge. That's what this is about. This new system is going to give us an opportunity that when that judge signs that bench warrant is electronically going to move to public safety and eventually using interoperability standards, data exchange standards. Eventually, that data is going to move into the squad car. We know it works because we instituted e-citation at the district court several years ago, and this year we processed 639,000 citations and never saw a piece of paper. Everything is moving by way of to the data warehouse electronically down into our system. So that's what this is about. Moving data quickly, real time. So we're going to be able to share information with our justice partners. The legislature has mandated guess this doesn't work. The legislature has mandated an interoperability requirement that we work with our major justice partners and meet an interoperability standard. It's going to facilitate better and informed decision making also. Let me give you an example of that. One morning at North Avenue, I had an individual in the criminal docket, domestic violence criminal docket, where I found him guilty, and as a condition of probation, I ordered him to stay away from his wife. He walked out of that courtroom, went down to Fayette and Gay Street, got a temporary protective order, and when the victim in my case, when she returned home, the police was there putting her out of the house as a result of the civil order that he got. This system is going to prevent that type of inconsistent decision making. Because with this system, a judge sitting in criminal will be able to go over and look at the civil system and see what's pending. Look at the family system and see what's pending. It's also going to enable us to move this information faster. It's going to allow faster enforcement of court orders. How many times have you read where someone's been murdered and news reporters kind of track it down and the person was on probation, but the probation agent has sent the request for the warrant over to the judge, and somehow the warrant went to the wrong agent and things of that sort, and someone got killed? Happens all the time. We just had a case a year or so in Baltimore City where that happened. That's going to stop this because all this information is going to be electronically transferred. Access to justice. Under this system, the bar and the public will be able to view cases remotely 24/7 anywhere in the world. I can tell you right now the debate at the Rules Committee is going to be whether or not we're going to open that up to the public and just how much access is going to be allowed, or is it going to be limited to just the parties in the case. That's going to be a debate that you need to be part of. It's going to improve support from litigants. It's going to reduce barriers to access. I can tell you right now at Glen Burnie, we're testing in our self-help center at District Court, we're testing document assembly where a litigant can come in and the computer kind of helps them assemble whatever pleading they need and electronically goes into the system. It's going to enable access again anywhere, anytime, and it's going to provide new electronic delivery options. You can actually, the technology is such that now when a motion is filed, the system can be set up so that you'll be notified on your BlackBerry that something's been filed in the case. And if you use a vendor, you can actually integrate with your case management system where you can actually get a tickler to tell you when the response to that motion is due. The technology's there. I think my battery went dead on this.
Probably turned off.
So much for technology. Let's see. Fair and efficient administration of justice. Again, more timely, more complete data is going to reduce delays. We're going to have better scheduling and coordination. And we're going to facilitate, again, better decision making. Also, the technology. We just entered into a contract with Tyler Technology, which is a premier vendor in this area with dealing with court technology as it relates to case management. So we have the most reliable, up-to-date technology. I have chaired an advisory committee for the past 4 years. This advisory committee consists of the experts from all 4 levels of court. And we have spent the past 3 or 4 years working on this. This group is going to oversee the implementation. We're going to act as a technical liaison to the Rules Committee. We have actually produced a document that I have forwarded to Dana Williams, who is the chair of the subcommittee for the Bar Association that's working with us, where we have made recommendations that Joan's going to talk about a little later. We are going to work with the Rules Committee, and we are working basically with a 4-step process. The first thing we did was we hired a consultant that came in and took a look at our judicial information system and answered the question whether or not we were ready for this. The answer was no, so we took about 2 years to make some internal changes to get ready for this. We have been planning this for about 2 years, and now we're at the process where we have hired the vendor and we're actually doing what we call the gap analysis, where they have installed their software and we're looking for gaps in their functionality and what we need in terms of functionality. Next stage is going to be the implementation. This is the vision. I'm going to move through this very quickly, but this vision basically is a paper-on-demand system. It's a system where it's going to allow for e-filing, and we have proposed a $5 fee, and that has not been finalized. But members of the bar, litigants will be able to electronically file with the court. The clerk is going to do an electronic review process, and then for the life of that case, it's going to be electronic. So all those folders now that you see, the pink folders, orange folders, green folders, all that's going to disappear, because the record as we know it is going to be the electronic record. Of course, the Rules Committee is working on how do you supplement that record with certain exhibits, for example, guns and things that you can't scan in. But we're going to work through those issues. Decisions made by commissioners, judges, and clerks, it's all going to electronically flow. What does that mean for you? If you go to a typical judge's chambers now, you have a duty judge. That duty judge goes to his or her basket, gets the work, which is request for postponements and things of that sort, signs off, puts it back in the basket. The clerk takes it and contacts you, puts it in the system. With this new system, when that judge comes into the chambers, he or she will go to a 27-inch monitor, and that work will be electronically queued, which means that the clerk no longer has to go into the judge's chamber and try to find the work. That clerk will be able to electronically tickle that judge and say, do your work, touch the screen, send it back, and send it out to you for those of you who are e-filing. So it's going to save a lot of time in terms of that. Again, interoperability. The legislature has required that we work with our major stakeholders, major justice partners, and be able to transfer this information using data exchange standards to move warrants, dispositions, commitments, and things of that sort. All this information is going to move electronically to law enforcement, to local detention centers, to all the other different agencies. Case search, as it is now, is going to be updated. Instead of just seeing docket entries, you're going to be able to, assuming that the Rules Committee decides this, you'll be able to actually look at that case file remotely. The question is going to be, are they going to allow individuals beyond the parties to do that? And again, paper on demand. Right now, if you want a piece of paper, it costs you 50 cents to copy that. The proposal is if you want to download and copy that, it'll be 50 cents. That's the proposal, and we're going to work through that this summer and this fall as to the final fee schedule. Let me just quickly take you through this. So actually, we're going to be able to, and this is the big issue that you need to pay attention to. Right now, the proposal is you will be able to continue to file manually. I can tell you that when the Rules Committee met the first time, the first issue that came up was whether or not it makes sense to continue this with a dual process, or should the Rules Committee adopt rules to make it mandatory for certain case types with some flexibility of allowing the administrative judge to allow you to opt out. That is your issue that for the next year you need to weigh in on. That's a big one in terms of the manual process. But there is going to be a manual process where the paper will be scanned, reviewed by the clerk, fees will be collected manually, paper files will be recycled, and then once that information is scanned into the system, for the life of that case is going to be electronic. E-file. Again, e-filing, this is going to allow members of the bar, self-represented litigants, justice partners to electronically file. The clerk's duties are going to be changed in that they're going to be doing an electronic review of the documents. Once the documents are docketed and accepted for the life of the case, that case is going to be electronic. The benefits, again, is going to be 24/7 access, increased service flexibility, eliminate process delays, eliminate paper files and the costs associated, and it's going to minimize redundant data entry. What's that? Your typical civil case right now, if you start at the district court clerk enters it into the system. If the case is then appealed to the circuit court, it's re-entered again. If it goes to the Court of Special Appeals, it's re-entered again. If it goes up to the Court of Appeals, I don't think they have a computer. So it's going to eliminate that redundant entry, and that once that information is initially entered into the system at whatever court, for the life of that case, is going to move electronically. Fees will be collected electronically and manually. Again, the proposal is a remote filing fee of $5. In terms of getting started, all you need is software, hardware. And what we're going to do is we're going to offer what we call both a vanilla and a multi-vendor program, which means that you will be able to use you can file directly with the court, or you can choose to use a vendor. The vendor option means that your law firm will contract with a vendor, say like LexisNexis, they're the big ones out there. That vendor will then file with the court, and then the system, it'll be electronic. The advantage of using a vendor now is the notification services, and also the vendor has the capability of integrating with your case management system, so you'll be able to track all those wonderful billing hours and all the other information that you do in private practice. But we expect to realize the same benefits using the vendor. 24/7 increased service, eliminate process delays, eliminate paper files, minimize redundant entry, fees will be collected electronically. Now, in terms of the judges, we have actually set up a focus group, both at the circuit court and the district court, the focus group of judges that are currently designing the workflows back in chambers, the workflows from the clerk's office to chambers, the workflows from the clerk's office to the different level of courts. So under this system, clerks, judges, commissioners, all that information is going to move, again, is going to move electronically. I'm having problems with technology today. So all the events, the dispositions and decisions will electronically be entered. Systems, of course, will limit access to certain of this information. Judicial actions will immediately flow into the electronic case file. We're going to integrate 4 levels of court. It's going to support court operations, eliminate paper files, system capacity and continuity. This is a big one. Just imagine this. If this system goes down, what happens? Well, we're going to have a fail-safe system that if the primary system goes down, it will be able to roll over, and within minutes, we'll be up and running in terms of the fail-safe system. It's going to eliminate process delays, instant access to decisions for litigants. So imagine this, sitting in your office, you have some judge that just will not rule on stuff. You will be able to, from your office, look into that case file and see where the judge is. You'll be able to tickle the judge or tickle the administrative assistant and actually get the judge to be a little more timely in their decision making. Interoperability. The legislature has mandated that we be able to move all this information by way of interoperability standards. So that means in terms of data scheduling, dispositions, and other information, all that's going to be electronic. Much like the district court in terms of how our traffic system works, it's all electronic. This is going to eliminate those process delays in terms of documents sitting on someone's desk and someone getting killed because those documents are sitting around on someone's desk. It's going to increase the flexibility of the justice partners and to the bar. And it's going to eventually, we're looking for reciprocal receipt of information, service of process. Those lawyers who will be electronically filing will be able to serve each other electronically. Imagine this. Mr. McCurdy will appreciate this in his criminal practice. A lot of afternoons in district court, you may have a summons case. Everybody's there, but no one's been served. Victims are there, but no one's been served. This system is going to allow law enforcement to electronically notify us when there's service. This system's also going to allow us to, when your client is not there and a judge says, where's the defendant? Well, I think he just moved from the county detention center down to Baltimore City, or maybe he's out in Hagerstown or the Eastern Shore. This system is going to allow us to go in using a common identifier that we're going to work out with public safety. We'll be able to locate exactly where that person is. So instead of issuing a bench warrant, we'll be able to issue a writ to the correct institution. So this is really going to have an impact in terms of how paper moves with our justice partners. Case search is going to be updated again. This is a big issue that you need to, this is paper on demand. Whenever you need paper, if you have to have paper, you'll be able to get paper. And this is what I've been telling my appellate judge friends. They don't want to read and scroll, so they'll be able to print those briefs out. But I can tell you, that's going to be debated as to what they're going to want the lawyers to do relative to electronic movement of briefs, extracts, and things of that sort. So that's a big issue you need to pay attention to. As for case search, that's the next issue you need to take a look at, is how much access are we going to give? Some states that have done these systems have opened it up to everyone, and now they're trying to pull it back. Now, the question here is, how far is the Rules Committee going to go here? Is the Rules Committee going to only allow the parties in that case to have total access to the electronic file, or is it going to allow your neighbors to just kind of sit and look at all the files, or is there going to be degrees of access? That's going to be debated by the Rules Committee, and you need to pay attention to that. Ability to review non-confidential documents remotely. These systems, you can actually put levels of access, filters on these systems to prevent access to certain confidential information. Parties will be given the authority to print the documents for free. Non-parties will print, download for a proposed charge. That's the proposal that's on the table that we're going to have to work through this upcoming fall and the next legislative session. Because we're going to have to either go to the Board of Public Works or to the legislature to get any sort of fee schedule approved. The Rules Committee does not have the authority to promulgate the fee. With that, I'm going to turn it over to Joan Nairn. She's going to kind of give you an update in terms of where we are and exactly where we're going to go. Joan.
Okay, got mine. Thank you. So where we are right now is we already completed the RFP. We sent an RFP out on the street in September of 2010. We received all the responses in November, and we created an evaluation committee. We actually went out to other states, like states, and looked at the software in action to determine whether it was going to meet our needs. We had vendors come in and do demonstrations to us, and we finally made it a contract award in October of 2011. This year we have started our project planning. As the chief mentioned, we're doing gap analysis now, where we're having people from the courts come in, take a look at the software, determine what things need to be changed in the system or where we potentially need to make business process changes. So that's our gap analysis. Obviously, if we have 8 or 9 case management systems today, we're trying to convert to one, we need to convert all that data. So we're going through processes today to identify that data, what the like data is and the format, and start working on that. One of the things we're also concerned about is obviously with all those different case management systems running on their own databases, what's going to happen when we convert to one? And we're one statewide system. We don't want to have performance issues. So the vendor's going to have to do a performance prototype for us to show us that when we start pushing all this data through one system, that we're not going to have performance issues. So we're coming up with training plans. Obviously, judges need to be trained different than clerks. Lawyers, if you're going to be e-filing, need to be trained. So we're coming up with training plans on how we're going to do that across the state. And then we're going to be working on these program modifications. What development does the vendor need to do? And then user acceptance. We'll have users come in from the courts and tell us that the changes we made are appropriate and that the system's going to work the way we need it to. So as the chief mentioned, we selected a vendor named Tyler Technologies. So who is Tyler? They are currently in, I believe, about 7 or 8 statewide implementations, Minnesota being their first. We actually have somebody from the Minnesota implementation who has since retired from Minnesota, who's actually on our team now, who's helping us through because of their experience with the Minnesota implementation. They're in New Hampshire, North Dakota, South Dakota. They're currently implementing in Oregon. They're in New Mexico, Indiana, and then a bunch of municipalities. So they have a lot of experience, and they're working very closely with us on this. So success, I just want to give you some ideas of what success they've had in other implementations. Dade County, Florida. They had issues of 40,000 square feet of paper was being stored in Dade County. Their family division measured their work in how many feet of paper they processed per day. And they wanted to eliminate what they call the invisibility of backlog. And what does that mean? They had no idea how far behind they were because they couldn't see all the paper. There was paper in the judges' chambers, there was paper in the courtrooms, there was paper stored in their clerk's office, everywhere. How do you determine how far behind you are on cases if you can't even see all of it? So they wanted to get rid of that. This family division, as I said, measured it in feet of paper. They processed 805 feet of paper a year, which is taller than the tallest building in Dade County, Florida. So they implemented this system, and the outcome was they were able to reduce the number of manual steps to process a piece of paper from 21 to 7. The 17 clerks that were involved in doing nothing but pulling paper were all able to be redeployed. This wasn't anybody losing their jobs. They were able to do other jobs, such as the quality assurance of looking at those e-filings and those type of things. And they have 1,700 attorneys who are now using e-filing. Another one is Clark County, Nevada, Great Las Vegas. They had lack of courtrooms, and they couldn't get the funding to build a new courthouse. They had a high cost to store, retrieve, and handle that paper, and a delayed time to dock it because of all the paper. This was what their storage unit looked like for all their files, and they actually were potentially going to be shut down by the fire marshal because they had so much paper. So they implemented the same system that we're looking at implementing, and the outcome was they had 100% participation in e-filing. Now, where they got the pushback on this was that their couriers pushed back more than the attorneys because the couriers were afraid they were going to lose business. Well, actually what happened was they put kiosks in their lobby of their courthouse. The couriers didn't lose business. They actually got a little extra money because some of these lawyers would then give the couriers an extra fee to go and use those kiosks and e-file directly from the courthouse. They also were able to build 4 new courtrooms, and this was the progress. This is the area where you saw those files. That was all cleared out, all that paper was gone, and they were able to put 4 courtrooms in the spot where they had all those files stored. Didn't have to build a new courthouse, they had the room right there. So as the chief mentioned, we created, I think it's a 153-page document when we started looking at what are the issues around a electronic case management system. And this is what we've turned over to the Rules Committee for them to start considering. We put things in buckets to try to, when you've got that many issues, we try to put them in buckets. So the main issue bucket is called the electronic court record. Then there's the receipt and the notification of that. And we put those issues in a bucket called filing, and then the access to those records. So, of course, a bucket called access, updating of those records. And we put all those issues in chambers, courtroom, and front office, and then the sharing of that. And so that's our interoperability. So I'm going to give you an idea of just some of the issues that we put in those buckets. The electronic court record, what's the acceptable format? today paper, but in electronic world, are we going to allow WordPerfect, Word, JPEGs, all those type of things? Well, it's kind of been solved for us with the vendor that we chose, because they automatically convert all the documents for us. So you can have WordPerfect, you can have Word, whatever. It will automatically convert that to a searchable PDF when it's fed into our system. So that issue's kind of been resolved for us. However, we are still looking at, in circuit court, we know that a lot of lawyers submit proposed orders, and then the judge may make some changes to that. So we're also going to allow proposed orders to be submitted in Word format. The judge can make those changes, and then it'll be stored as as searchable PDF. Destruction and retention of originals. So what's going to happen, today we have retention policies for keeping the paperwork, but does that change in the electronic world? Do you now keep it forever? What is that going to look like? And then the long-term archival. Right now we send things to the Maryland archives at a certain time frame. When you're electronic, how does that change? The next bucket is the electronic filing. Receipt filed confirmation. So if you can file, right now you have to be at the courthouse by 4:30 or whatever time they close to file your paperwork. Well, in the electronic world, you can be sitting home in your fuzzy slippers at 3 a.m. filing cases. So how does that change the receipt and filing? Because you can file it, but until the clerk gets there the next morning and actually reviews it and accepts it, what are those dates? So we're talking to the Rules Committee about that. We're going to track the date when it was submitted by the lawyer. We're also going to track the date when the clerk accepted it, but what's going to be the actual filing date? So we're looking at those issues. Deadlines. Do deadlines change now in the electronic world? Component failure. So what if you're sitting in your law office at 11 o'clock at night working late and you submit something and one piece of the system is down? Say your VPN from wherever you're at isn't working. How are we going to handle those? What are the rules around that? And then rejections. We talked about the clerks actually being able to review. Today, if you walk into a clerk's office and you hand them a piece of paper and say, I want to file this foreclosure case, and you've actually handed them, I don't know, an adoption petition, they're not going to take it and file it as a foreclosure case. They'll probably look at it and say, I think you handed me the wrong document, and they handed it back. Well, if you're filing electronically, we want to look at, do we have that same ability to hand it back with comments? The system will allow us to do that, but the Rules Committee needs to look at what are the rules that will allow a clerk to do that. Because today it's really supposed to be non-payment, non-notice of service, and non-signature, those type of things. So are we going to expand that functionality for the clerks, or are we going to keep that tight? Service, as the Chief mentioned, we're going to be able to electronically serve people. So are there any new rules we need to come up with that? E-filing exceptions, are there going to be certain types of cases that we say will absolutely not be allowed to be filed electronically, and they'll have to stay in paper? Bulk filing, we have asbestos cases today in Baltimore City, and we had landlord-tenant cases, which they're filing huge cases today. What are those bulk filings going to look like in an electronic world? Certification, basically, what's the process for you as a lawyer who wants to file with us? What's going to be your certification process to be able to log in, get a user ID, those type of things. We were actually meeting with the Rules Committee just last week, and those were some of the issues we were really talking about. Redaction, that's another thing the Rules Committee is really looking at right now. They're kind of leaning towards it's the filer's responsibility to send a redacted copy. We've talked about whether we would have you send 2 copies, a redacted and unredacted copy, and we would lock down the unredacted copy. I think they're leaning more towards it's your responsibility to send us the redacted copy, and then if it's ever requested, you would have to file the show us the original unredacted. So those kind of issues are being addressed right now. Access. So again, as the Chief mentioned, public versus private. Today, in case search, you go out and you just see docket information. In electronic world, all those documents will be out there, all the petitions, all the orders of the judge. So who will be able to see those sitting home, in their living room? Right now, we're looking at it's probably going to be parties in the case will be able to see it. Public will see what they see today and nothing more, but those are still being addressed and looked at. Internet versus courthouse. Today we have public access terminals in the courthouses that you can come in and you can see more information. We're still going to do that, but are there any changes we need to make to that? Bulk data access. We have companies that screen scrape our files at night and sell the information. Well, that's been a concern for us for a long time. We're going to lock that down some so that doesn't happen. And then again, the fees for access that the Chief mentioned. Courtrooms, chambers. Physical site requirements. One of the things we're doing is we're rolling this system out on a county-by-county basis. Anne Arundel County is our pilot, and we're scheduled for fall of 2013, and then we'll be moving to other counties after that. We need to come out to each of those counties and look at what the physical site requirements are going to be. If we're going to be electronic and there's no paper, what if there's evidence to display? The judge will be able to see it on his touchscreen monitor, the clerks will be able to see it, but what about the plaintiff, the defendant, the witness, the jury? They're going to need access to that information too. So we're going to have to come out and look at every courthouse, every courtroom, figure out, based on the configuration, what equipment's going to work, what's not going to work, and then get that equipment installed in all of those courtrooms. Entry in the courtroom. What we saw in other states that really worked was they had 2 clerks in the courtroom and all the data entry was happening right then. When court ended, everything was done because the clerks entered the information right then and they were finished. So we're looking at doing that. We're looking at what happens when somebody submits new evidence during court. Are we going to scan it right then, or do we hold it and scan it after court? All those type of issues we're looking at. Order generation and distribution in the courtroom. E-signature, that's another thing the Rules Committee is addressing right now. The software allows us many types of options with this. Each judge would have a password and they would key it, would automatically put an image of their signature, or whether we use the /S/ those type of things. We're looking at all those right now too. And then redaction, what happens if something's submitted in paper and it's not redacted? What's our responsibility to do those redactions? Interoperability, this is standards. Right now, I think we've identified 138 different agencies that we send information to and different types of feeds, and they're all in different formats. With this system, we want to kind of narrow that down and say, we're coming up with a library and saying, okay, if you want warrant information, this is what the data is going to look like, and this is how you're going to get it. And there's going to be one file, and this is the format. If you want information about civil cases, it'll be in this format and you'll come get it. If you want, different types of information for state's attorneys and any other agency that we're going to interface with. Replacing all those existing interfaces, we don't want to take away anything anybody's getting today. But now we also are going to, as part of our site visits, we're going to come out to each county and say, who do you interface with and how? Who do you interface with in paper, parole and probation, sheriff's department, all those different agencies? Who do you interface with and how? And we want to start working with those agencies to see what things we might be able to make electronic that aren't today to make this whole system work better. And then, of course, the responsibility of the judiciary versus receiving entity. We have some issues right now with, I get calls probably 3 or 4 times a month with people who are complaining because they got turned down for a job, they got turned down for an apartment because somebody did a background check and it's showing information on them that they've had expunged, they've had sealed, and what happened is somebody's come in and taken information from our system, from our case search system, and they stored it in their system and they don't update it. So when we expunge a case or we go back and shield or sealed something later on, they're still keeping on their system the old information. So we need to lock that down so these kind of things stop happening. Okay, so what's our plan from this point on? As I said, 2013, we're going to be doing that preparation for the pilot. We'll be doing those site surveys, the interoperability, identifying those equipment needs, coming out and doing user training. For the attorneys, we'll be scheduling training sessions for the attorneys who want to e-file with us, and then converting that data. Our pilot go live, we're anticipating is the fall of 2013. Then we're going to spend about 6 months in Anne Arundel County before we go on to the next county, because we want to do what we call lessons learned. We want to know what we did right, what we did wrong, fix those things, because we want every county after that to go smoother and smoother. Now, when I said we're doing county by county, it doesn't mean that we're going to do 24 implementations. Smaller counties will group together. Based on circuits, we'll group together, those type of things. So I think right now I have on my schedule will be about 10 implementations. So we'll be grouping counties together based on geographical area and size and that type of thing. So we plan on having this complete by the end of 2016. Any questions?
$5 filing fee that you talked about, or that was talked about, is that contemplated as a one-time fee per case or per file?
Now it's, the recommendation, as you'll see in the letter, is per file. But that's, don't get upset.
Every time you file a document in a case, it's another $5?
Yes, that's the proposal now. But at this point, we're going to take a look at that this summer, this fall. We're going to get input from the bar, And it's going to be driven by what the Rules Committee also does with this mandatory versus discretionary issue. I can tell you, we sent the letter out, and the Bar Association hasn't responded yet. But hopefully, given the fact we're going to put a bill in next year, we'll get that response from them.
Now, I want you to also understand that when we say per filing, if you're filing 5 documents at one time into the same case, they all go in the same envelope, and that's a filing. So if you have 5 documents that you're filing into a case all together, that's one filing. So it's not $5 for each of those documents as long as they're being filed at the same time together.
But for every motion, every response to a motion, every certificate of service of discovery certificates, each one of those, if they're filed separately, would cost a separate $5 fee.
That's the proposal now. So?
Say similar, it's not a money, it's a question of filing. If you're filing then 10 suits on Friday, but it's filed at one time, it's really going to be docketed as each 10 new cases. So that would be based on the proposal, $5 for each case.
Right.
No matter how many pages we're talking about.
Right.
What about a proposal where it's $20 to file the case, $10 for a motion, and $1 for a certificate of service? Because the certificate of service, that's where it becomes agreed. That's where, from my perspective, I got to file with. I just served him with the interrogatories. That's
If you're e-filing and the other party is also an electronic filer with the state, then you can electronically serve them.
Okay.
And you don't have to, it would be all as part of that same service.
That's a 45-cent stamp in an envelope.
But I'm saying when you submit your document, it can serve them at the same time. So you can file and serve at the same time. So you can file it with the courts and at the same time serve the other party. And that's all.
Well, in discovery, we don't file with the court. We only file the.
And if they are electronic on our system, you can serve them and not file anything electronically with us. So there's no fee. You could be filing with serving with other parties.
Okay.
And it never even comes to us.
The bottom line is this is where we are.
Okay.
This letter we have sent to the bar twice. We're going to send this letter for the 3rd time to Dana Williams. Because we're going to have to go to the legislature next year. All of your comments now that you made today, please send them over to Dana. Because we haven't decided this yet. We want to hear from the bar. We want to hear from the bulk filers, the landlord tenant, the asbestos, and we have to put all this together. This is just a proposal we just kind of like.
I'll tell you, I'm thrilled to hear what I think I heard in the end when you were talking about the data miners and including them as equity partners in this expungement process. Because all you civil guys don't realize it, but if your kid goes to college and he's a freshman and he gets busted for pot in Ocean City, if he's dumb enough to apply for an internship or something before he gets his record expunged and LexisNexis gets a hold of it, he's hosed forever. Because you can expunge his record till the cows come home. The private guys bought it. They won't participate in the expungement. You're not, so you guys are on to this then. You're going to make them, if they sign up for the data, they've got to start participating in the expungements. Is that going to be a piece of this? Because that's a huge problem. And it's a problem that a lot of lawyers didn't catch on to until their clients started not getting jobs when the economy went bad.
Yeah, we're looking at creating MOUs with all of those
Good.
entities. So
That's got to happen.
You were talking about regarding judiciary case search and having parties able to view the entire file and non-parties just viewing maybe currently what we have. What's the system options or different ideas that have been thrown around as to how you're going to say whether or not you're a party and whether or not you're just a viewer of the document?
A party would have a login to be able to log in and access that information.
And what we're going to do is we're going to look at all of the states that have gone through these issues. In fact, this 150-page document that I sent over to Dana, and I guess you can get that. Please take a look at it. What we did was we looked at the federal system, we looked at states that are designed or structured much the way we are, and the committee took recommendations based on how they've done in other states. This access issue is huge because those states They started out, some of the states opened it up. It was, everyone got a chance to look at this. And once you open it up, you can't quite pull it back. So the Rules Committee is going to be looking at that issue very closely in terms of how they're going to do that access issue.
Right, we're looking at other states. Minnesota, for example, on criminal cases, they don't even display on their public access a criminal case unless somebody has received a guilty verdict. So there's different ways other states have done that. We're bringing all that information to the Rules Committee for consideration.
Yeah. Next week, I think I meet with the Press Association, so you can imagine what they're going to be saying to me in terms of what they're going to want to access, and I'll just refer them to the Rules Committee. But I mean, we're going to, we'll hear that debate from everyone.
As part of the research, how much is Minnesota charging for filing?
Minnesota, even though Minnesota was the first customer with Tyler Technologies, when they started with Tyler, there was no e-filing back in 2002 with their product. So they're just starting e-filing right now. So what we found, we went out to a court technology conference back in, was it October? And we met with a lot of other states that are getting systems like this. And what we found was no state has the perfect solution. None have done something that they said this really works for us. They're all trying things. Some have charged the $5 fee, some have $10 fees. Ones that use LexisNexis, I think they're charging a lot more, like $14 or something like that. There's some who've tried it free and now are going back and charging things. So the thing is that, nobody has an answer that says
it's all over the place.
Yeah.
What we've done is we have a chart where we've taken the states to see what the fees are and where the fees going. Because one of the decisions the legislature is going to have to make is if they charge a fee, is that money going to the general fund? Is it going to a special technology fund? Or is it going to go back to replenish the land record fund? Because right now, the entire judiciary's IT budget is on the land record fund. So once we deplete that, which is given the market in terms of real estate, they're going to have to make some decisions next year what they're going to do with this money. So some states have actually charged up front with e-filing. They use that to build out the access portion, and once they got that built, they stop charging. Some have charged the access to pay for the e-filing, so it's all over the place. But I can tell you, the average is about $14, $15. We are low. This $5 recommendation is on the low side. So
we actually have a vendor that we work with to do some research for us, and they're actually supposed to have a report to us next week with what other states have done, whether they started mandatory or whether they started voluntary, and what mandatory, if so, how much did they charge, and all of those type of things, so we can have one report to look at what other states have done and help do that.
The big question I got this year when I briefed the House Judiciary Committee from Delegate Lou Simmons is, have the states started out and increased the fee? So we're going to have to answer all those questions when we go back to those legislative committees next year. But we're going to have the input from the bar. I can tell you, before we put that bill together, we're going to want the Bar Association sitting at the table with us saying, yeah, this makes sense. Okay? So this summer and this fall, we'll be reaching out to you in terms of what this is going to look like. And all those comments that you made today, please make them, because we haven't completely thought this through. Other questions?
Are these fees going to be assessed as court costs?
No, this is
I mean,
this is going to be above and beyond court costs.
Okay, so it doesn't get added to the court cost like a renewal summons. I get that $5 back at the end of the case if I collect. Okay.
No, this is going to be for the convenience to file remotely.
Okay.
The money that you would spend on the copier, the runner to get it down to the court, all those monies that you're spending now, that money's going to be moved over to that fee.
Okay.
And like I said, in terms of your profit model, in terms of how you bill and all that, that's going to change so much, because now you've got to figure out where you're going to make your money. That's the reality of the situation. That's why it's very important that you kind of think this through in terms of how it's going to impact you in terms of your practice. But the decision is not final yet, sir.
Have there been any special provisions for self-represented litigants?
We're going to think through that. In fact, I'm making a presentation to the Access to Justice Commission in May, and we're going to have to think that through. In fact, we're going to have Tyler Technology come in and do a presentation and give us some comments in terms of where all this is going in the future relative to self-represented litigants. That's going to be a difficult situation. But that's the reason we put together the Glen Burnie Help Center, is that we're now testing some of that technology in terms of document assembly and things of that sort to see in the end, are we going to use that type of technology for self-represented litigants. That's something the Rules Committee is going to have to decide. You know, the Rules Committee may just say, okay, in the beginning, we're not going to allow self-represented litigants to file electronically. I don't know. I think that's what the feds did. Or they're going to say that the trial judge or the administrative judge in a given case is going to have to make a determination that all the parties have the capabilities and they're all certified, even if it's self-represented or represented by attorney. You can have that mixture and everyone can e-file. But all that's going to be worked through in terms of how we deal with self-represented litigants. But you're not going to have a case where you have e-filers and you have manual filers, because that's a little too much. Next question. Ma'am?
For the equipment that's being installed in the courts, who's picking up that cost? Is that being paid by the state or
You are.
each county?
What do you think this is?
You
are.
Budget.
The money is coming out of the land record fund. We just hired, just signed a contract with Tyler. That money is coming out of the land record fund right now. And again, the legislature is going to have to decide next year if they're going to move that budget back to the general fund. Either way, you know, you're paying for it. Now, in terms of the localities, as we start to roll out, we're going to have to develop a list of expenses, and we're going to have to decide who's going to pay for what. Who's going to maintain the system? Who's going to pay for the equipment for the sheriffs? Who's going to pay for the equipment in terms of public safety? All those decisions are going to have to be made, and most of the rollouts are going to be, it's going to take about 18-month lead time in terms of our implementation schedule, so that the localities can go through a couple budget cycles if they need to fund some of this. So some of it's going to be locally, most of it's going to be state out of the land record fund. That's where we've gotten the money so far. I guess after this year, the legislature will have appropriated about $34 million out of the land record fund. Questions, sir?
What are your plans for cases that are already filed, and then as you transfer it to the e-filing, you're going to go back and scan them? Or are you gonna...
Well, our plan is day one forward. So when we implement this in a county, from that day forward, all new cases will be made electronic. All the data, of course, will be converted over. But what we're suggesting, and we're going to leave this to the discretion of the clerks because they know their cases best, but if they touch a case that's still on paper, a motion's filed in that would be a good time to go and back scan it to make it completely electronic. However, in some circuit court cases, we have boxes of paper for a case, so it doesn't make sense to back scan that, right? So that's why we're going to leave it to the discretion of the clerks, but we're making recommendations that they back file every time a case is touched. But it's going to depend on how big it is and that type of thing.
Sure.
If you're not going to have any mixed cases where electronic and non-electronic filing are permitted, how do you know up front? For example, if I file a district court case against somebody, I don't know if they're going to be represented by counsel once they get served, if that counsel is going to be trained on the system, and so forth. So if
I guess there's going to be, I guess the way it works is a trial judge is going to have to make that decision if all the parties, once that initial pleading, that initial complaint is going to be in paper, that initial service. Then afterwards, then the judge will be able to determine if the parties are certified and they have the capability to participate electronically.
And this is something that the Rules Committee is looking at right now, and we'll have a clearer answer after our next Rules Committee meeting.
But from where you stand now, the default will be it starts as a paper case, and then it might go electronic if everybody is up to speed?
That's probably the best way to do it. Yeah. But the Rules Committee is going to work through that. But if you're out there and you're a practitioner and you know the other side is electronically capable and you're electronically capable, then that case is going to be electronic. Unless I assume the Rules Committee is going to give the administrative judge or the trial judge the authority to opt out for good cause. But that exact issue is being discussed now, and that's why it's very important that you weigh in on this now in terms of how that's going to work. I understand I've had discussions with Judge Wilner. He intends to invite in different practice areas to really comment on this mandatory versus discretionary e-file. I've had discussions with Dana Williams, who's chairing the subcommittee for the Bar Association. He is going to be invited to the meetings, and he'll be able to weigh in on how this is going to work. Other questions, comments? Ma'am?
Is this going to cut jobs?
No. This is not going to cut jobs. This is going to allow us, and let me use e-citation as the best example. 2 or 3 years ago, the district court instituted electronic citation. This year, we processed about 639,000 citations where I never saw a piece of paper. So we had 26 individuals who spent their day manually entering 1.3 million citations a year. We have now redeployed and retrained 16 of those individuals that no longer work in that unit. We have now a core unit of 10 individuals. But what it does in the long run, it means I'm going to request less positions from the legislature, because what I'm doing is I'm taking those individuals and moving them out to the pen vacancies that are existing out in the location. So no one is going to lose a job. That's the big concern that the clerks and everyone has. Actually, it's going to be a different type of job. That clerk who spends his or her time now chasing files all day may be that clerk that's sitting in the courtroom, that second clerk who's capturing that real-time entry of data. So there's going to be a retraining. It's going to be a better job. Plus, it's going to give us an opportunity to take those clerks, in the back and move them to the front and give more customer service, because we're going to have these computer terminals there where there's going to have to be some help on those. Yeah, that's the plan. And we've looked at how states that have implemented these systems, how they have redeployed their people, and that's how it happens. No one loses a job. But with that said, if I'm out there being a carrier delivering paper, I think I would probably think about investing in another job or doing something else. I mean, that's the reality of the situation. So a lot of people say, well, you can't give me, the world is there. And for us not to be there, I think it's just simply wrong. Because you think about how important our decisions are, what we do on a daily basis, we should have the very best technology to make the very best decisions. That's what this is about. Other questions, comments, ma'am?
Do you know where Baltimore County is on your deployment timeline?
We have a tentative schedule together right now. The executive steering committee that we formed is going to be meeting on Monday, and I'll be presenting the schedule to them for approval, but I can tell you Baltimore County is about 4th, 5th, something like that.
Yeah, what we want to do is we want to get Anne Arundel County in, then we want to get Montgomery County in, and probably Prince George's and Baltimore City, then we'll move out. I mean, those are the larger counties that have their own separate systems. So, and it all depends in terms of how quickly, once we work through the user acceptance and we, test and go through acceptance testing and get this together, how fast, Tyler Technology can move this along. Because it's money for them to the extent they're not here 7 or 8 years, they're here 3 or 4 as opposed to 7 or 8. So I think it's going to move pretty fast. They'll probably move faster than what the implementation plan is going to look like, I'm hoping. But then again, I have 25 months, so hopefully I'll be moved on myself. Other questions, comments?
Is there a way we can check it online? Is there a forum or like a status, anything online that we can keep it all right there?
Yeah, what we do is every briefing that we've done, we actually take all of the questions and we have all the FAQs. We go back and we list answers to the FAQs. And if you go on this site, you'll actually see the charter, the communication plan. Eventually, there's going to be the implementation plan. You have the FAQs. You have this presentation, and I think it's a good, we'll probably talk to the Rules Committee about updating, and you'll be able to go in and see exactly where the Rules Committee is too.
Yeah, we're working right now on trying to come up with better ways to communicate with external people to the courts and also people within the courts, because we know that, we have people who work in the courthouses today who don't even have email because of the job they do, and how are we going to communicate to them about what's going on? So we're looking at, I'm working with the Office of Communications to come up with better ways, not even just this website, but I'll have an internal website that will have more information for internal people, and then, more information that we can put out externally as we start making decisions. So we're working on that now, but keep checking this website for one to get more information.
Well, as you can see, this is going to really have a huge impact in terms of how you do business and how we do business. So it's important that you really, the next year or so, really pay attention to this in terms of what the Rules Committee is going to do, what the Court of Appeals is going to do in terms of adopting the final rules and how this is going to look. So we thank you for having us, and we look forward to working with you once we get to you in terms of the implementation plan. That there will be a team that's going to work with the Bar Association once we get to your county. Thank you.